Hello, my name is Colt Wallace. This is my authentication video for family law, PLG-432. This is my ID. In this authentication video, I was tasked to go over my thoughts of the case Michael H. versus Gerald D. This case was a weird one. Very odd, with an odd holding at the end. I don't agree with the holding at all that the Supreme Court held for numerous reasons. And I don't think it's right to hold someone's own child away from them, especially if they're the biological father. With that being said, a little summary of the case, or what the case was about. Gerald D. was the presumptive father of Victoria, since he had taken responsibility of her since her birth for more than 2 years. Gerald's wife, Carol, had an adulterous relationship prior to Gerald and Carol getting married. This adulterous relationship was with one Michael H. Michael believed so strongly that Victoria was in fact his child. He had a paternity test done, which showed a 98% probability that Victoria was in fact the daughter of Michael and not Gerald. Once Michael obtained these results, he went to the court and asked for visitation rights to be able to visit with Victoria. Gerald immediately argued, saying he had no ground to challenge Gerald's paternity since more than 2 years had passed since Victoria's birth. The court ruled in favor of Gerald and canceled Michael's visitation rights. Michael took it to the Court of Appeals, where he claimed that California Evidence Code Rule 621 violated his 14th Amendment, his right to due process. California Court of Appeals upheld the constitutionality of Code 621. The Supreme Court held that a biological father does not have fundamental right to obtain parental rights after the presumptive father has exercised significant responsibility over the child for more than 2 years. So let's break that down. What that means is that a person has stepped in and played the role of father for more than 2 years. With that being said, the biological father then has no right of visitation rights because the presumptive father has taken responsibility for the child. Now the question at hand is, do I agree or do I disagree with this? And wholeheartedly, I can say I disagree with this for many reasons, for numerous reasons. The first reason I disagree with the holding of the Supreme Court is because the legitimate father does not have the chance to connect with his own daughter, his own flesh and blood. He doesn't get a chance to introduce her to his family, teach her family history of his own, or even be a part of family holidays. I disagree with this wholeheartedly because I believe every daughter or son, every child should have the opportunity to meet their biological father, no matter the time that's gone that they haven't met him. The second reason I say that I disagree with is it takes 2 years, or it could take more than 2 years to find out that you have a child and get the paternity test done. So all of a sudden the 2 years has expired and the presumptive father can challenge your right to parental right or visitation rights. So then you are just lost, you've lost your child essentially. So is 2 years really enough time to, let a biological father or mother for that matter make his appearance? The third reason I believe, and I really think this one's the biggest, is the fact that the presumptive father could not be providing the life for the child that the biological father could. The biological father could, on that same token, not provide the life that the presumptive father could. There's a lot of ifs there, but again, the child should go with the person that's best suited for them, whether that be a presumptive guardian or the biological guardian. The second part of my authentication video was I was supposed to go over my thoughts of the existence of the shack-up laws. The shack-up law, quote-unquote shack-up law, is illegal in Mississippi for two adults to live together and have sexual relations under the same roof and while these adults are unmarried. Absurd, right? They can get fined more than $500 and 6 months in jail. This is something that you hear older parents and grandparents saying you cannot move in with your significant other until you're married. So I absolutely agree that this is absolutely, the shack-up laws are outdated. And that's for many reasons. For first reason, living together now is easier. In a day and age where the dollar doesn't carry you as far as it used to, it's cheaper to live with a roommate, to split the bills, to split your cost of eating and other costs. It's absolutely cheaper for you to live with someone else, and if that happens to be your significant other, so be it. My second reason, and I say this all the time, is how do you know you want to marry someone if you've never lived with them? You learn a lot by living with someone, and if it's against the law, you never have the opportunity. The third and probably most important thing is this happens every single day, and it's just impossible to regulate two adults that live with each other consenting to something. I mean, it's absurd to think that the law would try and stop that. So with that being said, I agree wholeheartedly that the shack-up laws are antiquated and probably should be done away with. Even though they're still there, they're not enforced, so it really doesn't make a difference. Again, my name is Colt Wallace, and this has been my authentication video for Family Law PLG-432.